Okay, welcome to the first event of the Investment Treaty Forum in 2021. My name is Yari Krivoy. I am Senior Research Fellow in International Economic Law at the British Institute of International and Comparative Law and Director of the Investment Treaty Forum. Today's event is devoted to annulment in investor-state arbitration. I would like to welcome all members of the Investment Treaty Forum and guests. We have around 120 people who registered for this event, primarily lawyers working for big law firms, government lawyers, as well as some academics. This is our online-only format, and we began this format in the second half of the last year. And I think it works very well because we are able to reach more people than in the past. And it's also easier for some of our panelists to join without having the expense of traveling all the way to London from the United States or from Canada. We have two panelists today from Canada and the United States, and the rest of us are based in London. I would like to thank Baker Botts and Johannes Kopp in particular for initiating this study on annulment in investor-state dispute settlement. It was a very serious effort, and we'll talk more about the substance of the paper in a few minutes. Now, let me just say a few words related to the procedure of our today's event. So after this initial introductions, I will let Judge Joan Donoghue from the International Court of Justice to chair this event. We will have our initial presentation of the main findings of the paper, which will be followed by comments and a Q&A session. For our Q&A session, we are going to use the Q&A functionality embedded in Zoom. So essentially, the way how it works is you need to type your question in the Zoom window, and others will be able to see this question, and people will be able to vote for this question if they like this question. And in the event, if we have more questions than time to address those questions, then those questions which receive the highest number of votes will be asked first. We will also try to connect people asking questions using video, because that gives us more real or live experience compared to just using text. So be prepared to turn on your camera or at least your audio when your question will be selected. If you are using social networks, Twitter, LinkedIn, Facebook, we encourage you to use ITF Law hashtag. You can find it also on the event page. This event is recorded. We will publish the presentations, so the initial presentations, but we will not publish the Q&A session because we want to encourage people to ask their questions, and not if they do not wish to be seen asking those questions, then this will essentially help us to achieve that. With this, let me turn the virtual microphone to Joan Donoghue, who is a judge at the International Court of Justice, normally based in The Hague, but now I think Joan is based in Washington, D.C., where she also spent much of her career working as a lawyer, focusing primarily on public international law. She was also working for the U.S. State Department. She was elected to the International Court of Justice in 2010 and re-elected in 2014. And we are very grateful, John, for your that you spent this morning in the United States, or afternoon here in England, with us discussing annulment in investor-state disputes. John.
Well, thank you, Jarek, for those kind introductory remarks, and welcome all of you members of the audience. It's true that I'm in Washington today. Tomorrow, assuming that I pass the 2 COVID tests now required by the Netherlands, I'm headed back to The Hague. This is a terrific study, which Andrea and I had a chance to review in draft. And I think you'll all find it very interesting to hear what these authors have assembled as materials. So we'll hear today from Jarek, who has already indicated his role at BIICL, as well as from Johannes Kopp, who's a partner at Baker Botts, and his associate, Jack Biggs. The three of them have been working over a year on this study, which I have very much enjoyed reading. I'm not going to preempt what they have to say about the substance of the study today. I just thought I'd step back a bit and reflect on what the importance of empirical work is. Because in dispute settlement, as an adjudicator, one is often presented with assertions about facts. And of course, those who are making the assertions are advocates, which means that they are seeking to portray the facts in order to support whatever point they're making. So it can often be quite difficult to disentangle advocacy from facts. And if we move from the hearing room to policy debates, we see a similar dynamic, which you're all familiar with, as participants make representations about the status quo in relation to investor-state dispute settlement that may not always present a fair picture of the facts. That may not be an effort on the part of a participant to distort things. It may actually reflect the fact that individuals extrapolate from their own particular experiences, maybe even with a small set of cases with which they've worked directly. So an empirical study really provides an opportunity to reshape the way that all participants in the arbitration field understand and think about the annulment mechanism. Of course, empirical work itself is often developed for the purposes of advancing a substantive objective. We've seen many studies of that sort. But this study, I think, has as one of its strengths the fact that it attempts to set out information in a more objective way. So I think of it as a study that once it is released, many members of the audience will want to slice and dice to meet their own interests, their own objectives. As you'll see, for one example, when you look at what's been developed today, it will immediately invite questions in your mind about the relationship between outcomes in ICSID annulment on the one hand and non-ICSID annulment on the other hand. And I understand from the authors that they contemplate, in fact, a follow-up study on precisely that topic. So I think it will serve as a launching pad for whatever future topics and issues interest the authors, interest the members of the audience, and the investment arbitration community more generally. So with that, I will turn it over to our presenters. I understand that Jarek will begin with some introductory remarks, and we'll then hear from Johannes, followed by Jack. When they are finished, Professor Bjorklund will provide some commentary. I'll give her a brief, when she's finished with her commentary, I'll ask the authors if they want to respond to anything that she said. And once that's done, we'll see what questions there might be from the audience. I mention all of that so as to suggest that if any members of the audience have questions they want to put forward, they could perhaps be sending them forward in the course of the remarks so that we have a chance to take a look at what questions might be posed when the authors have finished reacting to Professor Bjorklund's comments. So with that, Jarek, I'll turn the floor to you. Thank you.
Thank you very much, John. This study on annulment in investor-state disputes is the third study which the Investment Treaty Forum conducts with its members. And it's certainly the longest study. We have not yet released the text of the study. In the past, what we did in the pre-COVID time, we would give paper versions of the study to people in the audience so that they can read and then ask comments, but we're not releasing the study itself in electronic format because there is always something to change as a result of this, of our launch events. So we hope that this event will also help us to improve the study and perhaps to mention some of the issues which we were not considering in the paper So it's not only a learning experience for those who participate in this event, but also for us how to improve the study. But you will see the slides, and the key findings of the study will be presented today. And within a month, we will finalize the study, and those who registered for this event, they will be the first to receive this study. As Joan mentioned, we started working on this over a year ago. And I remember that the only in-person meeting we had on this study was in February 2020, just before the COVID situation began. And since then, we were working online, collaborating, and analyzing over 150 cases dealing with annulment in ICSID proceedings and also in non-ICSID proceedings. Let me now share my screen. So why did we decide to conduct this study? The main reason why we thought it was important to look into this was because ICSID annulment seems to be the most powerful, although an exceptional mechanism to overturn awards. So the ICSID Convention provides for reasons, for limited reasons, on which parties can apply to annul awards. And if an award is annulled, this has a very significant consequences for the parties. And as you know, investor-state disputes often involve millions, hundreds of millions, or even billions of US dollars. So the consequences of these annulment decisions are very important. And although many different views were expressed on various aspects of annulment, on how to reform it, but there was no coherent empirical study looking at how actually tribunals approached annulment, be it ICSID annulment or non-ICSID annulment in domestic courts. So we thought it would be good to help lawyers who work for law firms, who work for governments, also investors, to understand better how to use this annulment process, what to expect, what not to expect. And also, we hope that this study will facilitate more legal certainty, so that those who use annulment or consider using annulment have a better understanding what to expect and what not to expect. And also, we hope that this study will serve as evidence for policymakers in the future, because at various institutions, including ICSID and UNCITRAL, currently there are discussions how to reform the system of investor-state dispute settlement, and making ISDS jurisprudence more consistent, more predictable, is certainly one of issues which is often discussed. And this study will hopefully help to give evidence for those who want to reform the system. Before we look into the study itself, let me say a few words about the history of annulment. I was looking through ICSID drafting history, and annulment did appear in many discussions between members, between various states which were participating in drafting the ICSID Convention. And it was very clear from those discussions that the idea of annulment is not the same as the idea of appeal. And the chairman, Aaron Brochers, of the drafting committee actually said that mistake of law and mistake of fact constitute an inherent risk of proceedings. So annulment is not there to fix mistakes of law and facts, but it's an instrument to fix in exceptional circumstances serious procedural violations. And it was also interesting to look the drafting history, because it helped to understand better why, for example, the drafters decided not to include the same annulment grounds as those which we can find in the New York Convention. And the idea was that ICSID proceedings was modeled more on the state-to-state arbitration rather than on the commercial arbitration. And this is why the limits, the reasons, the grounds for annulment were quite limited. Also, it was interesting to see that the delegates discussed a stay of enforcement. So what happens if there is an annulment procedure initiated by one of the parties? Should there be an automatic stay or enforcement or not? Some states argued in favor of that, but eventually the decision was that it's not automatic, but it's at discretion of the annulment committee. And these discussions about how to improve the annulment process still continue. So, for example, ICSID in 2012 discussed a rather long document, 176 pages, discussing the annulment process and its how tribunals approached it in the past and how they should approach, although they were not really looking into all those fine details which our study covers. And the reason why they decided to look into that back then was because Philippines was unhappy with an annulment decision in Fraport versus Philippines, which essentially annulled a decision favorable for the Philippines. So they were criticizing the lack of limits on the discretion of tribunals when they look at annulment decisions. They're also criticizing the fact that there were not enough developing country representatives on the annulment committees, and so ICSID Secretariat discussed those issues in great detail and reiterated that annulment proceedings should have exceptional nature and they should not be used as an appeal. Unity Trial Working Group 3, in which some of those who participate in this event also take part, discusses annulment as well and how to reconcile annulment with the New York Convention grounds for annulment and grounds for refusing to enforce or recognize arbitral awards. They were thinking how to make sure that those grounds do not overlap, or perhaps they're also considering whether to merge those grounds. Different views are expressed on this point. ICSID itself is considering establishing an appeals facility, which will be different from its annulment process, but also has to, if it happens, then it will have to coexist sometime with ICSID provisions dealing with annulment. When we look at the architecture of annulment process, as I mentioned, it looks more like a state-to-state process, for example, similar to that which we have at the International Court of Justice or at the European Court of Human Rights, where domestic courts have no role to play in annulling decisions or there are no appeals either. So the grounds are very limited. And although ICSID in many respects looks like commercial arbitration, private adjudication, but when it comes to annulment, it does look like a state-to-state or a purely public mechanism. We in this study we covered primarily ICSID annulment. However, we want to do a follow-up study looking more closely at non-ICSID annulment decisions and comparing ICSID patterns in ICSID annulment decisions and non-ICSID annulment decisions, because there are significant differences. One of the findings, and Jack and Johannes will talk more about our findings, was that parties are much more successful in annulment proceedings for non-ICSID decisions compared to ICSID decisions. Most of us are very familiar with the difference between the New York Convention regime and the ICSID regime. Under the New York Convention, courts in the seat of arbitration have a role to play. Also, courts in the place of enforcement have a role to play. So potentially either annulling an award or rejecting recognition and enforcement. Also, if you think about adjudicators, they are quite different. In the annulment process, the ICSID Secretariat essentially appoints all three members of the annulment committee, while if you will look at the New York Convention regime, then these are domestic judges and sometimes judges in more than one jurisdiction. Also, the grounds are different. Under the New York Convention, you have public policy, for instance, and it's not included in the ICSID Convention. And there were discussions during the drafting history of the ICSID Convention, which show that the drafters were not in favor of having this public policy exception. They wanted to have procedural grounds only. With this, let me stop and pass the microphone to Johannes, who will actually start giving you the data, our findings. Johannes? You can share, or Jack, perhaps you can share the slides. I will stop sharing on my screen and you can share on your screen.
Okay, thank you very much, Jarek. I'm both pleased and honored to be able to present to you some of the results of our study today. This review and analysis of 192 annulment decisions has been a tremendous team effort of our arbitration group here in London, mostly managed on a day-to-day basis by my colleague, Jack, who's going to present with me today. So before I kick off, I just wanted to say thank you to all of my colleagues who have been involved in this project and who have worked tirelessly on this project from their respective home offices over the last year or so. On my first slide, you can see the dramatic increase in ISDS annulment proceedings over the last decade, where the first ISDS arbitration annulment proceeding was registered, the first ISDS arbitration was registered in 1972, and the first ISDS award was rendered in 1977. The first annulment application, Klöckner 1, wasn't registered until 1984. The number of annulment proceedings then remained relatively low in the following years. Just 4 further proceedings were initiated in the 1980s and 1 sole proceeding during the 1990s. These very low numbers then increased very significantly over the last 20 years. First, there were 31 additional registered annulment proceedings in the decade from 2000 to 2009. And then from 2010 to 2019, not less than 101 applications. The number of proceedings registered between 2010 and 2020 accounts for more than 3/4 of the total. This impressive trend mirrors, but outpaces the growth in ISDS arbitration proceedings generally. The percentage of ISDS awards subject to annulment applications has increased steadily from 10% in the 1990s to 40% in the years from 2000 to 2009, and then 50% in the last decade. Some states are responsible for the bulk of these applications. Argentina, Spain, and Venezuela in particular. Collectively, these 3 states alone account for nearly 45% of all annulment applications submitted by states, and over 1/4 of the 159 annulment applications registered by ISDS in total. These states appeal as a matter of course. For example, both Venezuela and Spain have appealed 12 of the 14 unfavorable awards made against them. Increased familiarity with the annulment process may be one reason for the increased willingness to resort to annulment. Other reasons may include, at least in the case of Spain or other EU countries that had to arbitrate under the Energy Charter Treaty or intra-EU bilateral investment treaties, the requirements of EU law following the Mikula judgment, or other political reasons, such as, for example, the desire to delay payment, avoid enforcement altogether, or at least to be able to show politically that everything was done to overturn a negative decision. Jack, can you turn to the next slide, please? The overall success rate of ISDS annulment applications remains relatively low. Only 19 out of 192 awards have been successfully annulled. The overall success rate of annulment applications is about 15%, with states being more successful than investors. Only 7 awards have been fully annulled. 12 awards have been partially annulled, with the most commonly annulled parts being damages in 5 cases and jurisdictional findings in 3. Next slide, please. Successful annulment proceedings can lead to resubmission proceedings. Our study has shown that in 10 of the 19 successful annulment cases, resubmission proceedings were initiated, which then led in turn to 4 further annulment proceedings at the conclusion of these resubmission proceedings, and 1 further successful annulment. And that was the MCO2 case. Let's move to stay of enforcement. Here, we could observe. Jack, can you turn to the next slide? Here we could observe a truly remarkable trend. Applications for a stay of enforcement used to be granted by ad hoc committees almost as a matter of course. Up until 2016, the date of the last ISDS study on annulment, only about 10% of all applications for a stay of enforcement were rejected. In the last few years, however, ISDS annulment committees have looked much more critically at the state's desire to postpone or avoid enforcement. Almost 50% of all applications have been rejected since 2017. While the outcome of these enforcement stay applications has thus changed quite dramatically, the decisions of the ad hoc committees show that the legal criteria considered as relevant in assessing a stay application are still pretty much the same. Prospect of prompt compliance with the award, hardship, risk of non-recovery, irreparable harm to the award debtor, dilatory requests for annulment, and a general balancing of interests. The new, more critical trend may in part be explained by the fact that in particular certain states now seem to apply for annulment as a matter of course, as we've just seen. The factual threshold for a state to demonstrate hardship, in contrast, is relatively high. Poverty as such, for example, is no reason. Not less than 9 of these recent cases have also concerned Spain. And the argument that a stay should be granted because of the legal quagmire that Spain finds itself in as a result of arguably conflicting EU law and international law obligations has been rejected in all of these cases. Next slide, please. Another significant, albeit perhaps less dramatic change could be observed in relation to the decisions on costs. Ad hoc committees in the past usually divided the cost of proceedings equally and ruled that each party bear its own legal fees and expenses. This has changed in recent years, although even by 2016, this traditional PIL position was still favored in about 40% of all cases. Over the last 4 years, however, you can see that this approach was adopted in less than 20% of all cases. So in only 5 of the 26 decisions on costs, the costs of proceedings were divided equally, whilst in the remaining 21 cases, at least some type of cost shifting was determined by the annulment committee. In about a quarter of the cases, the committees even ruled that the losing party should bear some or all of the winning party's costs. If you can, Jack, if you can quickly turn to the next slide, there you can, I think we've got these, exactly these 2 pie charts that illustrate this change that has taken place over the last years. Next slide, please. As Jarek already mentioned, whilst we plan to have a follow-up study later this year on non-ISDS annulment proceedings, we have also started looking at setting aside or annulment proceedings in relation to non-ICSID investment awards. So awards rendered under the ICSID additional facility rules, UNCITRAL rules, ICC rules, SCC arbitration rules, or the like. Our research in this regard has shown a steep increase of annulment cases in relation to non-ICSID awards as well, albeit perhaps not as dramatic as within the ICSID framework. About 2/3 of the identified setting aside proceedings were initiated in the 11-year period between 2010 and 2020, while half of them were initiated between 2015 and 2020 alone. As Jarek already alluded to, non-ICSID annulment applications have a significantly higher rate of success than ICSID annulment applications. 26 of the proceedings resulted in full or partial annulment of the award. This is equivalent to 27.6% of the 94 concluded proceedings, which is almost twice as much as the success rate in ICSID annulment proceedings. Perhaps we can talk more about the reasons later on, but to my mind, this increased success rate may have to do with various factors. And again, Jarek already touched upon some of those. The arguably broader grounds for annulment in national arbitration laws. For example, a large proportion of the non-ICSID annulment applications was based on a violation of public policy, a ground that, as Jack will explain in a moment, is not available under the ICSID convention. Another reason may be a different standard of review. So, for example, de novo review of jurisdictional findings in certain state courts, as opposed to manifest error review within the ICSID framework. Different decision makers may be another explanation. So on the one hand, you have state court judges on the one hand, and on the other hand, you have arbitration specialists who may be more reluctant to annul the findings of their peers in an ICSID annulment proceeding than a state court in a state court judge in a state court proceeding. Or it could also be a reflection of a generally more investment treaty hostile environment that may influence state court judges more than the members of ICSID annulment committees. Jack, can you turn to the next slide? Some of the annulment grounds in the ICSID convention are more popular than others. Ground 2, manifest excess of powers, for example, is invoked in almost every case, followed by failure to state reasons. These most frequently invoked grounds are also the most successful. Ground 2, for example, has had a success rate of 14.5%. At the other end of the spectrum, in contrast, and I think very fortunately, is ground 3, corruption on the part of the Tribuna, which has never been invoked. But for a more detailed analysis of the specific grounds for annulment, I would now like to hand over to Jack. Jack?
Thanks very much, Yanis. So as Yanis said, the plan of this part of the presentation is to go through the 5 grounds under Article 52 of the ICSID Convention and draw out some of the main trends and statistics from decisions under those grounds. So turning to ground 1, which, as you'll see on screen, relates to the improper constitution of the tribunal. So this relates both to the constitution, the formation of the tribunal, how the tribunal deals with challenges to members of the tribunal, and also replacing members of the tribunal. So as you can see on screen, it's been raised in 13 applications. And I do note from the outset that where you can see 9 unknown, these are proceedings that we know happened, but we don't know exactly which grounds were invoked in those proceedings. So as I said, ground 1's only been invoked 13 times. And It's only been successfully invoked, as you recall last year in the decision in ISA v Spain, it's only been successfully invoked once. So so as I said, we've got 13 applications here. Now, 10 of those 13 applications under ground one related to the alleged failure by a member of the tribunal to disclose information. And the remaining 3 related to the alleged failure to comply with arbitrator appointment procedures. Now, in terms of the jurisprudence, I suppose there have been 2 main trends that have been applied when annulment committees have addressed ground one. The first was from Zurich and Argentina, which had a very, very narrow application whereby the annulment committee, their role is very simple, to look to see if the relevant procedural requirements have been followed by the tribunal. And that was the limit of that review. Then followed in 2016, the decision in EDF v Argentina, which took a slightly broader view, which held that in limited circumstances, a committee can review the merits of the original decision if that original decision by the tribunal was so plainly unreasonable that no reasonable decision maker could come to such a decision. And it was that approach that was adopted by the ad hoc committee in ISA v Spain in the one successful example that we are all no doubt familiar with from last year. So then turning to the second ground, which is manifest excess of powers. Now, as already flagged by Johannes, this is both the most popular, the most commonly invoked ground, and also the most successful. So as you can see there, in 76 out of 79 known proceedings, this has been invoked. And then turning to the next slide, we can see that there's obviously 2 elements to a manifest excess of powers when it's addressed by committees. The first is to look at, and define the scope of what, whether a tribunal has exceeded its powers. And then the second step is to determine whether that excess of powers, should it be established, was manifest. Now, when we look at the, what are the grounds, what constitutes an excess of powers, the decisions can be split into 3 categories. The first relates to jurisdiction, which, as you'll see on the screen, has been invoked successfully on 3 of the 11 occasions. And that can relate to either a tribunal's failure to exercise jurisdiction when it has jurisdiction, or conversely, when a tribunal exercises jurisdiction that it does not have. The second category, and as you'll see on screen, the most common basis that an ad hoc committee has found a manifest excess of powers relates to a failure to apply the proper law. Now, that may be the relevant national law, international law, the relevant investment treaty or instrument, or even customary international law. And as you can imagine, committees are very, very careful when addressing this to stop at the limit of what constitutes a failure to apply the applicable law and not the wrongful application of that applicable law. And then the third category on screen is where a tribunal has jurisdiction, but goes beyond the scope of that jurisdiction in another way. So in a way that doesn't relate to the applicable law. So, for example, in one case, in RSM v St. Lucia, that award was partially annulled on the basis that the tribunal manifestly exceeded its powers when it dismissed the investor's claims with prejudice. So that's the first part. Then the second step is obviously, well, if there is an excess of power, one must establish that it was manifest. Now, the overwhelming majority, so on 55 occasions, ad hoc committees have defined manifest according to its plain and ordinary meaning. So manifest must be something that essentially jumps up off the page. It's self-evident and does not require what you might say, I suppose, further analysis. Having said that, there is a small minority, about 15 committees, which have held that when you look at the notion of manifest, it can't just be a notion of something self-evident. There is also the requirement a requirement that it be serious, that there's a gravity to that excess of power. And then there's also a small number, an even smaller number of committees which have essentially held that manifest means both, and that it's one and the same thing. It needs to be clear, but also there needs to be a sense of gravity to that. So turning then to ground 3 and on to the next slide, which as Johannes mentioned, this relates to corruption. And based on a review of publicly available decisions, ground 3 has not been invoked or addressed by an annulment committee. So I dare say that the fact that it has received so little attention is reassuring, and we no doubt hope it remains that way moving forward. So then turning to ground 4. So ground 4, you could say in some ways there's a parallel with ground 2 in the sense that you have, the fundamental issue, which here is a fundamental rule of procedure, and then there's the additional requirement on top that it be a serious departure from a fundamental rule of procedure. As explained by 2 academics, the main purpose of ground 4 is to safeguard the integrity of arbitration proceedings. And as you can see on screen, while it has certainly been invoked on many occasions, that, I guess, popularity is not reflected, I suppose, in the success rate of applications under ground 4. So as I said, there are 2 cumulative requirements that must be satisfied. The rule of procedure must be fundamental, that's the first. And then the second is the departure from that fundamental rule of procedure must be serious. So when we look at the idea of what constitutes a fundamental rule of procedure, this is obviously not provided under Article 52 of the ICSID Convention. Instead, ad hoc committees have identified and consistently accepted that there are 5 different categories of fundamental rules of procedure, which I guess are relevant to ground 4. So the first of those, if we could turn to the next slide, should be the equal treatment of the parties. This has only been successfully invoked once. I think the key trend from reviewing the jurisprudence on this is that that if you have a fundamental piece of evidence, if you have a fundamental argument, the parties need to obviously be treated equally and given equal time. And I think that then ties in with this second ground, which is the right to be heard, which has been, as you can see, slightly more successfully invoked. And again, the key here, if, for example, you look at the jurisprudence, is that, again, it's not an absolute right. It's not a total right to be heard on absolutely everything. Tribunals are granted some discretion, but it is the right to be heard on the most fundamental points that affect the tribunal's decision. So then turning to the third, the next slide, please. Independence of the tribunal. So this ground, as you can see on screen, has only been accepted once, and that was the aforementioned decision in ISA v. Spain, where the tribunal decided that based on an objective, and that's key, objective assessment of the relevant facts, it would be manifestly apparent that Dr. Alexandrov lacked impartiality. So that's been, as I said, invoked once. And then we move to treatment of evidence. Now, as you can see on screen, this has been invoked on 19 occasions. However, it has yet to be successfully invoked. And as explained on the screen, there's a number of different, I guess, sub-issues that have been addressed within the context of treatment of evidence, including, as you can see, reversal of the burden of proof, disregarding evidence, and a failure to order the production of documents. And then the fifth and final ground is deliberation by arbitrators. Now, as far as we're aware, claims under ground 4 regarding the deliberation of arbitrators have been made on 3 occasions, but has not yet been successfully invoked. So then that's the first limb. The second limb, if we turn to the next slide, is that's what you consider a fundamental rule of procedure. But then we move on to what constitutes, sorry, if we go back, maybe that's been missed out, but that's fine. What, defining a serious departure. And I suppose there's 2 schools of thought on this, and it's been either you need to demonstrate that the party has been adversely affected by the serious departure, or the fact that you establish the serious departure is in and of itself is deemed to be in and of itself sufficient. Now, in 28 of the 34 times that issue has been discussed expressly by a committee, they've held overwhelmingly that one needs to show that the party was adversely affected. Now, the degree to which they are adversely affected, that has obviously that has differed between ad hoc committees, but that certainly seems to be the predominant trend when discussing that second limb of ground 4. And so finally turning to ground 5, which, as you can see on screen, it's the failure to state, or where the tribunal has failed to state the reasons on which it is based. And quite clearly, it has been regularly invoked, and it has also been the second most successful ground under Article 52 of the ICSID Convention. Now, again, as far as we're aware, there are no instances of a tribunal providing absolutely no reasons at all in respect to a dispute. And again, consistent with what Jarek was discussing at the beginning, ad hoc committees are very cautious or very keen to ensure that the ICSID annulment process doesn't, I suppose, warp or morph into some kind of quasi-appeal. And so the key here is the lack of reasons and absence of reasons, and not the quality of those reasons. Now, almost all of the successful applications made under ground 5 have been rendered on the basis that an award did not contain reasons on a specific point. In a small minority, a party was successfully applied for a partial annulment or a full annulment on the basis that there was contradictory reasons. And on that basis, the idea was that if you had contradictory reasons, they essentially cancelled each other out. And then by extension, you no longer had any reasons, and there was an absence of reasons. And the requirements under ground 5 were therefore satisfied. So I think it's very clear when one looks at the ground 5 jurisprudence that annulment committees are very conscious that they do not want ground 5 to be used as a quasi-appeal process, and that a high threshold must be met in order to satisfy that. So with those considerations in mind, I'll now hand the floor back to Jarek for his concluding thoughts.
Thank you very much, Jack. There are a number of interesting takeaways from our study, and you will be able to see them in full once the study is released. But to me, the most striking one was the modest success of annulment applications. As you have seen, there are hundreds of ICSID proceedings, but only in a handful of proceedings annulment applications were successful. And in a way that is justified by the exceptional remedy of annulment, right? So it's not an appeal, so it should not be a likely outcome that the award is annulled. However, over 50% of all ICSID cases face annulment proceedings. And the number of annulment proceedings is likely to rise, because a number of decisions on annulment is likely to rise, because a significant part of those decisions which were which are in our data set are actually pending decisions. So the decisions on whether to annul or not will be made soon. And we can think about the reasons why the annulment proceedings usually do not result in the outcome which the applicant is seeking. And one of the reasons could be that arbitrators understand the exceptional nature of annulment proceedings, but also probably they do not really want to be seen as revolutionaries, as those who disturb the flow of ICSID awards, because each tribunal constitutes of highly respected scholars, and usually there is a role for the ICSID secretariat in appointing the chair if there is disagreement between the parties. So the quality of those awards should be rather high. It does not necessarily mean that those awards should be consistent, but still, if I were on the annulment committee as an arbitrator and I was thinking of my future reappointments, probably I wouldn't want to be a revolutionary and say, you know, Professor this or another arbitrator was wrong, he got it completely wrong, there was a fundamental departure from the process and so on. So that may explain it. Also, if you think about the states' incentives, they are quite powerful to annul. So essentially, if states try to annul, they have not that much to lose. Of course, they have to pay their lawyers, but they can show those people who work for foreign ministries, ministries of justice, or other departments responsible for investor-state dispute settlement. They will show to their superiors that tried to do all they could to annul this award. And also, it looks good from the political point of view. We tried, we did all we could, but probably there's something wrong with the system. So I think that states have powerful incentives to actually try annulling. But another interesting finding is that just a handful of states are responsible for a very significant amount of annulment applications. So I don't know whether it means that other states are not aware about this opportunity, or they do not think that it's worth investing in lawyers because the success rate is not great. Another interesting thought, which we don't really discuss in the paper, but the role of ICSID Secretariat, and in particular ICSID Secretary General, is very powerful in annulment proceedings, because essentially it's up to the ICSID Secretariat to appoint all three members of the ad hoc annulment committee. And unlike, let's say, if you think about regional proceedings where each party has a role to play, or if you think about non-ICSID proceedings where not only the parties have a role in appointing their arbitrators, but also domestic courts have a role in annulment or in recognition or enforcement. So that's another area. When it comes to future reform efforts, this has not really been the purpose of our paper, but we look forward to discussing potential ideas with the audience, and I think Andrea will also have something to say about it. I can see that there are already a couple of questions, but we'll wait with responding to those questions until we're done with all presentations. Thank you, and over to you, John.
Well, thank you. Let's turn now to Professor Bjorklund to hear her comments on this very interesting study.
Oh, thank you very much, Joan. And thank you, Jarek, for inviting me to comment on this ambitious and timely project. It's really a pleasure to see you. I confess it's easier to be calling in from Canada in a sense, but I'd rather be with you in London. So I do have a number of comments and questions. Some of them are quite small, and I'll share them with you later. Some of mine are questions or comments or suggestions for further research. I'm aware it's always easy to be in the position of saying, oh, here's what you really ought to do. You should really spend, another 50 or 100 hours doing various things. So these are meant with a good heart and a suggestion for things that would be interesting to know. And of course, your study is especially timely given the attention that is currently being given, particularly in UNCITRAL's Working Group 3 to reform of investor-state dispute settlement. So I've divided my comments into roughly 3 different sections, those on conclusions from your study and effects on investment treaty practice, some questions about links to broader principles in international law, and then finally a few questions linked specifically to the proposal to establish an appellate body. These compartments are not exactly watertight, so a few comments could certainly fall within more than one category. So first, and just notwithstanding the increase in the number of annulment applications, overall the numbers are still pretty small, and certainly things like the number of successful applications are very small. So I wonder if you can really draw that many conclusions about things like an investor success rate or a state success rate when you have 7 awards that have been annulled in full and investors have succeeded 3 times while states have succeeded 4. So yes, states have a higher percentage rate, but one decision has gone the other way and you have exactly the opposite conclusion. Obviously the numbers would shift significantly. And I think that's true in a lot of these. Even if the numbers are bigger than they used to be, they're still not all that large. I also wonder if you've mentioned this, Jarek, you alluded to the fact that you have some kind of blanket seekers of annulment, and have you got numbers that exclude, I guess, Argentina and Venezuela to see what the outcomes are? Is there any significant difference there or not? I mean, a further thing you could try to do is to think about the think about the grounds on which annulment is sought and whether, I mean, you've done that a little bit already, but I'm thinking about linking the identity of the claimant and the grounds and whether there's anything to say there. Jarek kind of alluded to this, and I don't have an answer for you, so it's just a further question. But is there any way to tell what ought to be the outcome? I think, saying that there's a 2% success rate, states only, you can only get annulment 2% of the time, leads to some kind of conclusion that that's not very much. That's obviously not a very good, it's not a very good ratio if you want annulment. But is that what would have been expected or should be expected in a regime that is meant to be extraordinary and meant to be an exceptional remedy? So I guess I query what ought to be the win-loss rate, or whether there's any way that we can tell that. I think the next study, your follow-on study, is going to be really interesting as well, including some of the comparisons that presumably will be able to be drawn from it. But I think if you're looking at the kind of the non-ICSID cases, the set-aside cases in national courts, it will be important to really separate those into the different jurisdictions, because I should think that you're going to have a difference in outcome depending on the jurisdiction in which set-aside is sought, and also, to the extent possible, obviously the various grounds and how those grounds map onto or do not map onto the ICSID grounds for annulment. And I think you've alluded to that, in particular with respect to public policy in the paper. But I'd also note, having just participated in a study about attempts about due process, a comparative view of due process, both in commercial and in investment arbitration, it's very hard to get an award set aside on due process grounds under the New York Convention or under the UNCITRAL model law. So hard to resist enforcement as well. So we hear a lot about asymmetry in investment treaty arbitration. states can submit claims, investors can submit claims against the state, yet states cannot submit claims against investors. And some have suggested that this is why states are more likely to seek annulment than investors. States are the ones who are going to lose or win, and investors might be able to change a jurisdictional outcome or maybe a damages outcome that is they're not going to lose, well, they might lose a case on the merits, but that leads them to resubmission. Does your research bear this out? Are there other reasons that states have sought annulment more often? And I guess that does give rise to kind of a suggestion that you might want to disaggregate your outcomes depending on whether the claim is brought under a treaty or under a contract. So the early cases all involved claims brought under investment contracts. Does that make a difference in the outcomes? If investors have more of an incentive to seek annulment under the contract? In which cases, if any, did investors seek to annul decision that awarded damages against them as opposed to a merits or jurisdictional decision? And there I thought, it might be really useful to have a subsection just disaggregating merits challenges, jurisdictional challenges, and damages challenges, just to have those numbers broken out. I think you have that data. I wonder if there's any conclusion you can draw. You kind of mentioned that certainly you talked about this in your discussion, Jack, but do terms like manifest and fundamental make a big difference? Would there be a difference in outcome if, our tribunals kind of, or committees hung up on, oh, this isn't manifest. It's not very good, but it's not really manifest. Or is it, I don't know, and I'm thinking of that because of the attention paid in, let's say, in the CETA and other more recent investment agreements to kind of adjectival grounds for overturning, I guess, or for castigating national court actions. You mentioned that timing challenges, the timing issues regarding both kind of challenges to arbitrators and challenges to due process. And this is alluded to a little bit in the report now, but it seems to me there's something of a damned if you do, damned if you don't aspect to these issues. If you challenge them before the tribunal and you lose, you're very likely to lose again. If you don't challenge them before the tribunal, you are likely to lose simply because you could have challenged them and then you did not. And I thought you might be able to draw a little bit more on that. And I thought relatedly, you might want to elaborate a bit more on the deference, if any, accorded to questions that have already been decided by tribunals. This kind of leads into res judicata and what, to what extent, how many bites at the cherry should an investor, should a challenger have? I think it's I know that your goal is not to provide a treatise on reform of investment arbitration, and I do appreciate that. But I think it would be kind of interesting, and maybe this is not your project, maybe it's somebody else's project, but to really trace what effect, if any, challenge kind of decisions has had on initiatives, or annulment decisions have had on initiatives like the ICSID UNCID trial draft code of conduct. What about on kind of practice more generally, to the extent you can nail that down? In other words, is disclosure more and more sought, is more and more given? One of the responses, I think, to ICER, I mean, obviously this was the point of, or, the underlying question in ICER was that the information was not secret, it was publicly available, but it wasn't actually disclosed specifically. And kind of where do those lines get drawn? And in fact, I mean, so in a lot of instances, we have kind of a known or should have known standard. You know, in ICER, the committee found that Spain was not expected to have known because the information was not drawn to its attention, even though it was available on the record. Yet, presumably in other contexts, there is still some should have known responsibility on the part of the potential, I guess, challenger. And kind of shifting now to kind of the overarching principles question, but I'm thinking about the matter of waiver of rights. One of the things in ICER that the committee said was that Spain shouldn't be regarded as having waived any fundamental rights to something as important as having an impartial tribunal. And suggested that the waiver needed to be more explicit. But waivers come up in a lot of different contexts, and I wondered if there's anything at all that can be drawn from committee decisions on the question of waiver and whether states parties had or had not waived rights. And I'm thinking in terms of kind of challenges, having made challenges more generally or having made challenges to due process issues. Another kind of overarching principle that occurred to me was the question of judicial economy. So in Malaysian historical salvers, the failure of the arbitrator to consider whether the investment satisfied the definition of investment contained in the BIT was considered a manifest excess of powers because of a manifest failure to exercise jurisdiction. Yet, and the arbitrator had found that the investment in question did not satisfy the definition under the ICSID convention, and therefore the claim, therefore the center, there was no jurisdiction. The center did not have jurisdiction. But what about the link with the principle of judicial economy, right? If you have the double keyhole test, if you can't, if you don't have an investment under the ICSID convention, it arguably it doesn't matter whether you have an investment under the BIT, you're still you don't have jurisdiction. So I'm not taking a position on whether the definition of investment under the BIT should have an effect on whether you have one under the ICSID convention. That would seem to be a merits issue, but just the kind of the judicial economy question. So how do some of these principles interact? You know, we normally think that we are in favor of judicial economy, yet here we have a tribunal. I think it was a sole arbitrator, but we have a tribunal that was, in a sense, criticized for having exercised judicial economy. Similar kind of questions arise with respect to matters like parallel proceedings and duplicative recovery. You know, what effect do annulment decisions such as Vivendi 1 have on questions like the desirability of parallel proceedings with, a contract claim going on in parallel to the investment treaty claim and the interplay between contract claims and umbrella clause claims. Another kind of interesting question, which is the question and influence of obiter dicta. So I think one really interesting avenue of study would be the use of obiter dicta in annulment decisions. And you mentioned this in a few cases, on a few occasions, in cases that did find annulment, but I'm thinking that there might be a lot more to say on cases that did not result in annulment, but in which the committee lamented on the standard of review that prevented them from actually annulling the award. And if I'm thinking, in particular of CMS versus Argentina, but I think there are other examples as well. And then kind of finally on that note, I also thought about Jura Novit Curia. One of the few reasons but successful attempts to set aside or to annul decisions has been the failure of a tribunal to give parties the opportunity to comment on a legal issue that turned out to be definitive. And I guess, should the annulment committee have considered Jura Novit Curia on those occasions? And then my final just couple of questions having to do with lessons for a potential appellate mechanism. I guess, does it make sense to keep the same annulment standards in an appellate mechanism and to add the possibility of challenge on a point of law or a clear error of fact? What would the existence of a straightforward appeal be on annulment grounds, such as an excess of power or failure to state reasons, which have arguably been either expanded or, argued to be expanded to encompass errors of law, at least in a few cases? And then kind of my final point is, what about the possibility of remand? Annulment is something of a blunt instrument, which might in some instances have discouraged those seeking it. But if remand were available to fix errors, might annulment or appeal be more attractive? And I'm thinking of your 47% of cases in which resubmission is not sought, because you really have to start from scratch. Anyway, those are my comments in response to reading your really excellent report. And as promised, I'll give you some more detailed comments later, and I'll give you the write-up of these comments as well. But I really appreciated the opportunity to think about these issues, and look forward to getting the hard copy of the report when it's time.
Thank you, Andrea, for those comments and remarks, many of which I found very interesting. It also strikes me that you've identified quite a number of points that the authors will eventually wish to reflect on and to remark on. But before we turn to a discussion with the broader group of participants, let me invite the authors to make whatever comments they wish to make in response to Andrea's comments that we've received so far. So I'll let the three of you decide how you wish to proceed in terms of which of you wish to speak first. If you want to maybe put up your hand or something, I can
We'll go in the same order as we were making the original presentation.
Very well, we'll do that.
Okay. Yeah, thank you very much, Andrea, for all those comments. Everything is noted. Whether everything will be acted upon, we'll see, because these are all interesting issues. And the beauty of Excel spreadsheets is that they allow you to find quick answers to many questions, but not to all questions. And so we will address some of them. When it comes to the sample, indeed, we don't have that many successful annulment applications. However, we have quite a few applications in general. So we can, we just try to do the best with what we have. And it may take many years before the number of successful annulments will reach 20 or 30. And if someone wants to reform the system or just tries to understand how to use the system more effectively, I think that it's already a good contribution. But I agree that we can't make very bold generalizations based on a small number of successful applications. And annulment applications are indeed designed as an exceptional remedy, and that may explain why we have so few successful applications. But on the other hand, we can see that applications for annulment are far from being exceptional. In over 50% of cases, one of the parties, usually the state, did submit annulment proceedings, which may be explained, or the reason why some states are more active than others may also be explained by the way how they handle disputes, whether it's primarily in-house lawyers working for the government, or external lawyers, and how much control in-house lawyers have over the overall strategy in cases, whether they want to try to annul every single case or not. And some points on the UNCITRAL trial, on appeal, I hope to discuss them in more detail during working group 3 meetings, where we will try to share this this report as well to help decision makers, including dealing with the mechanism of appeals. As I mentioned, at the beginning, you can see that there are differences between private adjudication systems and public adjudication systems. In public adjudication systems, such as ICJ, for example, or European Court of Human Rights, or some other courts and tribunals, there is no such thing as appeal, or it's very limited. And even though in commercial arbitration, you normally cannot appeal the awards either, but the number of grounds is much broader. So if ICSID goes into this direction of having an appeal facility, then it will make it look more like commercial arbitration. But if the members of the appellate body will be appointed by states only, as it looks like the most likely outcome, then probably the states will not be too unhappy about it, and so it is a possibility. But let me stop here and pass the virtual microphone to Johannes for any comments.
Thanks, Jarek. Andrea, I just want to address two of the questions that you raised. First of all, you asked the question, why do states seek annulment more often than investors? And as I said in this first part of our session today, I think there are certain political reasons that may apply with equal force to all states. But then there are also specific reasons that I think only apply to EU member states. And now I'm obviously talking about the Achmea judgment, where, as you know, there's now this agreement for the termination of bilateral investment treaties under which member states are obliged to seek annulment of awards made under bilateral investment treaties. And although I don't think it's specifically addressed, I think mutatis mutandis, that would also apply to, or might also apply to awards made under the ECT. And so if you take this as the starting point, that EU member states have actually no choice but to seek annulment of an unfavorable ISDS award made under an intra-EU BIT or the ECT, and then look at the cases or at the applications that were brought by EU member states since Achmea under BITs or the ECT, then the statistics look, as you rightly suspected, completely different. So I think it were out of the 39 applications that were filed by EU member states under BITs or ECT award, 17, or so that's 44% or so, related to awards where they, at least from an EU law perspective, were obliged to seek annulment. So I think that's important to bear in mind. The other comment that I wanted to make in terms of the annulment rate, whether it's high or low or just right, it obviously depends on the comparator. So for example, if you compare the annulment rate to the rate in French courts with regard to commercial arbitration awards, then it is pretty low. If you compare to the success rate of Section 68 applications in the English commercial courts, it's actually pretty high. You know, in 2021, in the legal year, I think there was only one successful Section 68 challenge in the English court. So it depends. That's obviously a policy question to be answered by the contracting states. What I find curious, and that's just an observation, is that you have, on the one hand, you have this high rate of annulment applications that Jarek mentioned, on the one hand, and on the other hand, you have the very low success rate. So that's a bit of a mystery, perhaps. Jack?
Thanks, Johannes, and thanks, Andrew, for your comments and questions. I wanted to briefly address three of them. The first point you made regarding, can you, and correct me if I misquote here, but can you draw trends from such a small number of successful applications? Now, I suppose, obviously, from a statistical perspective, yes, for a number of these issues, there are, very small numbers of applications and even smaller numbers of successful applications. I suppose the one thing I would say is that when you go through a lot of these applications, what is quite interesting is how the the trend that is now widely accepted in a lot of these issues, obviously had to start somewhere. And it's remarkable how consistently, even though there is, ad hoc committees are, they're not bound by precedent in the same way certain national courts are. But it is remarkable when you go through the decisions how often committees do go back to the same cases. They do go back to the same trends, the same approaches to defining certain terms. So I suppose while maybe the statistical value of looking at some of these, isolated instances may not be very high, I do think from an analysis perspective, it is very useful because it certainly seems that when one ad hoc committee addresses an issue, a novel issue, it does seem like, unless it's particularly, unless it's something that's quite out of the ordinary, quite often the next ad hoc committees that come afterwards, they follow it, they adopt it and they approach, they build on that. So I do think from that perspective, looking at those isolated cases or those small number of cases could be quite useful for the future and how ad hoc committees will approach these issues moving forward. The second point, I think Jarek and Johannes have already touched on this regarding the expected win-loss ratio and the fact that it is, I suppose, in isolation quite small, and certainly when you take out some of the more heavily criticized early decisions, like Clocknote, and AMCO, it goes down even further. Certainly, I think when you read the negotiations and what the drafters were thinking when they drew up the ICSID convention, I think frankly they'd be pretty happy with how it's ended up, because it is meant to be an exceptional remedy. So I think would we expect a higher win-loss ratio? I think it is consistent with the overarching goal. Thirdly, you asked if these ideas under ground 2 and 4, so the idea of a manifest excess of power or a serious departure from a fundamental rule of procedure, whether they the extent that they make a difference, and I would argue that they make a significant difference, because I think time and time again, ad hoc committees stress that they're not doing a review, for example, under ground 2, they're not doing a de novo jurisdictional review, right? That this is very much their goal is very much for, I think, particularly exceptional circumstances, and they, I suppose, lean on this idea of there may have been an excess of power, but it was not manifest, or there was a departure. Sure, we accept that, but it was not serious. And I think that has come up in a number of cases where they have said, look, okay, maybe this is, an excess of power, but it certainly by no means reaches the threshold of what is necessary to constitute an annullable, error, so to speak. So I do think that, these ideas of manifest and seriousness, while there is some disagreement as to how they should be defined, that is true. There's obviously, as I said, there are different schools of thought on those issues. Be that as it may, I think there's nevertheless, universal acceptance that they are very important, and that the purpose of including those terms within Article 52 was precisely to avoid, review on the merits or anything less than something that was particularly exceptional.
Well, thank you, Jack, and thank you to all the presenters for their responses to Andrea. Andrea, do you have anything you want to say in reaction to what we just heard from the authors before we open up the discussion?
No, not particularly. I mean, I'd love to have a long conversation about many of these issues, but I think we should open it up to others now.
Great. Well, I'm sure there will be an opportunity to do exactly that down the road. I just wanted to make one comment of my own with a question to the authors. And it is that especially when we have a presentation that includes pie charts and bar graphs, we tend to think about empirical studies as studies that focus primarily on the quantitative side. And some of our discussion has been about the numbers and the relatively small sample set. But of course, empirical work can also look at qualitative aspects. And what strikes me about about ICSID arbitration decisions over time, as has been mentioned, is the frequency with which committee members like to refer to decisions of earlier committee members. It's not very surprising because whereas in a tribunal proceeding, part of what's being discussed is fact specific, and often one tribunal is discussing Treaty A and another tribunal is discussing Treaty B, et cetera. When we come to the application of the grounds for annulment, all the committees are applying the same grounds for annulment. I've wondered in recent years about the extent to which the ICSID background paper on annulment has helped to guide committees towards relevant so-called jurisprudence, and therefore to help to increase the probability that there will be more consistency or at least awareness on the part of committees of differing strands that have emerged in prior decisions. And so that leads me to my question, which is, to what extent do you feel like your study struggled against the fact that not all decisions are public? How much did that get in your way? And I wondered especially about that question in relation to stays of enforcement, because even when decisions are made public, there may only be a brief discussion of the grounds on which the committee rendered its decision on the stay of enforcement. And it's less common, at least I believe that to be the case, that the decision on enforcement itself is made public. So I was curious about how you think that affected your work, and more generally, how you think it stands in the way of a jurisprudence in relation to application of the grounds for annulment. Thanks.
Let me say a few words before allowing Jack or Johannes to talk about enforcement issues. I think the point which Jack made was quite important, that in the absence of positive annulment decisions, whatever we have is valuable, because it shows that there are already some approaches and tribunals have something to build upon. And I hope that the value of this study will be of similar nature, that tribunals can look at, or the annulment committees can look at our study to see what the patterns are. And John, I know that you are sitting, and you were sitting in the past on annulment committees, so perhaps you can also reference our paper at some point in the future. And some tribunals did it. I think that was related to our paper on provisional measures. So when there is nothing out there, there is no codification, there is no guidance, tribunals can interpret the international law or domestic law in any way they like. The value of this study is actually trying to make sense of that jurisprudence. But I'll let Jack and Johannes talk about the enforcement, because it's more of a practical issue.
On enforcement, we actually found a fair number of public decisions. So, Jack, I don't think that was a problem that we specifically struggled with in relation to stay of enforcement decisions, right?
No, not that I recall.
And also, we don't really know how many non-public decisions there are, because that's the nature. Because they know that some of them were registered with ICSID, and then, but there are also other non-ICSID decisions which are not registered anywhere. But yeah, so 150 was. We thought it was good enough for us to initiate a study.